Okay, so just had the conference with the attorney. It was very tense, very tense. So ultimately, I believe we have a strategy of communicating the exhibits that will have us with a victorious outcome. Um, I'm not going to be, I think it was a lot of unnecessary tenseness with some of the suggestions that I placed towards, the affirmations that are undisputable as far as custody. I think ultimately I can maintain a calm demeanor with that. That I think allow us to, conclude the discussion with a thorough mock summary of what's going to occur. That covered some of the things that I think need to be key. There are still some things that I think are key that he's just ultimately refusing on the witnesses. I think it goes towards showing that there was no neglect, that they corroborated on the stand that I was reached out towards. And there's other aspects of that that I think should be communicated, that he's just flat out refusing. And so ultimately, if things are not successful, that will be part of the appeal, and the preparations. That's very key. It's important for me to have those witnesses doing this portion because they're doing the time frame that I contacted them. It shows that they testified to that already. He tried to say that they were irrelevant, and then he said that the testimony would be only for the second portion of the trial, even though they were in the fourth portion of the trial last time. He was refusing three. Now he's going to call one. And so, I think all three of them are just as important. The other two has aspects that they already testified to that are even more important because they actually testified that, hey, we talked to him, but we didn't give him the information of where his son was placed. They testified to that on the stand, and that should be told at this aspect as well. He can't make a decision on neglect really without that. There's a lot more evidence of my interest, obviously, during that time frame, a 3 year time frame. There's obviously a lot more communication with paid lawyers, with expectations from agreements that were already made with attorneys that wasn't followed up on, as far as communicating court dates where we have one interaction 1 hour before court where you decided within that frame, the middle of that time frame, that you're going to give me a court date. Okay, an hour before the court date. That means there were court dates that were months before that when I eventually got the case filed that the clerk was refusing to give me. We see that you're getting paid for other court dates, and then you decide to call me for one day, the hour before, to mock the situation. As long as I see that email out of the blue within that hour. Okay, when you had the last court date from the one before that, when you could have contacted me that original day, and so we have the hostility as well with the warrant situation that was resolved, and then no communication after that. It's just called out, hey, we reached out to you. We reached out to you to give you a warning about a situation that's completely irrelevant. We're calling you to warn you not to show up in the court date at the court with this situation pending. That's what the letter establishes. And then there's no more communication about court dates until the one out the blue. Okay, you're supposed to be communicating those dates. We have proof that these clerks, like the homosexuals who are in the background, when you call them and ask them for court dates, they don't want to give you the court dates. The Air Force lady here, she don't want to give you the court dates when you call them and ask them for them. We have the attorneys saying that on the communications that, hey, we ain't getting you a court date. We can't get you a court date. You can give us a few grand, but hey, we don't roll with you like that. We have that in the communications. A month where they're not providing me with a court date. Okay, that's evidence that's within that time frame. Why should have been provided a court date? And so that's going to be communicated. There's things that you just cannot ignore. And he want to linger on these, and then the tenseness of the discussion again is lingering around the judge's decision initially not to hear my evidence that was complimented, okay, from other attorneys. It was complimented from other attorneys. These attorneys said, hey, in the defense, in their closing statement, hey, You guys have a systematic system where you don't return these children to their parents, and there's no reason for you to have that continuation with me based off of what my attorneys say. Oh, he as though the judge has a right to have animosity against my representation just because it's pro se, and he gave me all these warnings about how if you represent yourself, how in his 57 years of being an attorney, it's just not the right thing to do. That's irrelevant to what was prudent in the best interest of my son that you heard, okay, that you're going to hear again, okay, you're going to allow it. Do the right thing when you hear it this time, okay. You prevent there's a ton of things that I can cover, that I'm covering, that were just laid out violation of due process, um, suppression, hostilities from the DCFS caseworkers with just in person or with cancellation of visitations at the day of, um, um, not considering me for the placement to do the home study. As soon as I was contacted, hey, do the home study. Do the home study. An incident happened March the 13th, 2019. I should have been contacted then. I'm contacted the 19th. When you already placed my son in all these other locations without contacting me, you have diligence reports on the other fathers in the report, in the paperwork, but you don't have one on man. Because you knew if you had to do one on mine, you was going to have to acknowledge it in the files and then contact me on that same day that the other ones were started, which were around the 13th, the diligence reports on the other fathers. So you started mine on that day as well, and you didn't follow, and then for somehow it got lost in the wind. You didn't follow it. You didn't follow through on it. But you eventually followed up on it on the 19th after you'd already kidnapped my son and placed him in other locations. And then when you hire the attorneys to show up and you represent in your case, they already, I made the mistake of doing a search engine on these guys, and the search engine that bring up someone who don't do completely nothing jack of what you pay him to do, because he come to court on March the 26th. They continue from the 20th to the 26th. He shows up to that one, and I told him, even with the casework, I told him I want custody, full custody. I don't care about parental, a DNA check. I want full custody. Okay, I need a home study done where I'm staying at, which was in Iowa. You know, um, I get the attorney. I pay for the attorney to show up on March 26, 2019, and the paperwork shows that he shows up on that day, but yet they still publish in the paper Stephen King's. He finally wanted to talk about that today. The attorney, oh, you know how to. I believe my son's mother. Either they I believe she told them who I was on the first day, obviously, and they didn't do the diligence report on who I am, and then they convinced her to make up this whatever this name was they made up. They made her do that. That's why they published in the paper, because my attorney is on the paperwork. He's in the paperwork saying the dates that they published, the Stephen King, conflicts with the representation of my attorney being on the documents it's showing. On the 26th of March, Diggs' attorney, representing Kendrew Slater. So why I don't care what the mother said. You had willing acknowledgement with me being there. You had willing acknowledgement from her before that date. It's already dated. I have paperwork where she's told you, where you guys are stating my name from DCFS case assessment records, and yet this is before the notice of the publication of Stephen King on March the 29th. You have notice in the case assessment from DCFS stating my name. It might be real late in the report, but it's still in there, and it's before March the 26th and March 29th. And yet they still have this publication out to try to give some authenticity in the court for not having me in consideration for the home study. They should have did the home study. That's what I told the attorney I wanted. That's what I paid him for. To do the home study. He said, hey, it'd be easier for you to do the home study in Iowa and do your parental rights from there. I take his expert experience. You know, they like to, act like I'm just did the pro se out of ego. No, I paid money and these guys didn't do their job. He said it's better for me to do that out of Iowa. Once I saw that, okay, that he's not doing a good job in getting me my home study, now I quit the job in Iowa and came back to Chicago for the state's attorney, the white lady, I don't remember her name, who likes to say, "Oh, you didn't walk on glass." As you know, Your Honor, um, a parent will walk over glass for their children. They completely ignoring the evidence. I quit the job in Iowa and came here to fight for my son ever since. That's what the record reflects. I was fighting from there based off off of his advice. And then once I saw that his advice was failing, I quit the $100,000 job and came back here. Even though, as you can see, these cabals, I done fought through them by now. But as you can see, they can make, because I just quit on them and guess go to another one until I find someone who's honorable. But you will see with the YouTube video that they, right around the time I'm going to court, when I'm scheduled to go to court, and I'm telling them